an important day because the court decided in 1954, Brown versus Board of Education, enough of this segregation. The Constitution says equal protection of the law. Anyone alive at that time could look around to the South and say, you call that equal? I mean, please, they're the most unequal thing you could ever imagine. And everyone knew it. They said you have to be equal. So what happened in 1955? Nothing. 56, next to nothing. And then the judge in Little Rock says desegregate Central High. And the Little Rock Nine were prepared to go in, and we remember some of us the pictures of that day. And Elizabeth Eckford, turning this way, and this woman, her face filled with hatred. There in front of the school, and Melissa turned them away. Eisenhower. It was tough for him. Jimmy Burns, governor of South Carolina, Moderator, and was on our court and resigned from the war effort in World War II domestically. And he said to Eisenhower, don't do it. Don't send the troops. If you do, you'll have to have a second Reconstruction. You'll have to reoccupy the entire South. Are you prepared for that? Right. And Herbert Brownell, though, his trusty and wise advisor, the Attorney General, said, you've got to do it. You've got to do it. And he did. I simply remember. He took 1,000 paratroopers from the 101st Airborne, and everyone knew who they were. They were the people who parachuted into Normandy, and their parachutes got hung up on the steeples. They were the heroes of the Battle of the Bulge, and that didn't just happen by accident. But Eisenhower picked them. And he put 1,000 on the airplanes. They flew to Little Rock. And they escorted those black children into that white school. It was a great day for people of law. I usually tell the students I'd like to end it there, but unfortunately I can't. Because they spent a pretty awful year. No, not a year, not quite a year. The new school board got elected, and they got a decree that took them out of the school. And then they appealed that all the way up, and our court said at that time, you have to bring them in that school. You have to. And all 9 judges signed that order. All 9. Hey, but there were 9 judges, you know. Could have had 900. Could have had 9,000. The day after the court decided that case, Governor Faubus closed the school. And they stayed closed for months. Read what happened to a lot of the students, black and white, in those circumstances. It wasn't good. It was not good. But it couldn't last. See, it couldn't last because the schools then reopened. The people in Little Rock didn't want them to stay closed. They elected a new school board. That was the beginning of Martin Luther King, the Freedom Riders. But that's the point. I think that what happened with 1,000, trying to enforce the law, and the decision, Cooper versus Aaron, it was a catalyst. It was a catalyst. I'm biased. I believe it helped. I believe it helped a lot. You can argue that. I believe it helped. It catalyzed people. But it wouldn't have worked if it hadn't been for the others. I tell that to the Ghanaians. Or I spoke to a group of judges from Burkina Faso, Ouagadougou, Egypt. And they all want the same question answered. Why do people do what you said? And I can only tell them the story. And I said, but would you have to convince the people? Don't convince just the lawyers and the judges that the rule of law is a good thing. I mean, they tend to think it is. You know, but contrary to popular belief, there are 310 million people in the United States of America who are not lawyers or judges. And they're the ones that have to understand it. And it's not so easy because you're getting judges sometimes deciding things that are pretty important in their lives. And they're not popular. And by the way, I hate to tell you, judges are human beings. I know that's hard to believe, but judges are human beings and they can make mistakes. Bush v. Gore. I just said it. All right. Well, I heard Harry Reid say this about Bush v. Gore. He said the most remarkable thing about that case is something that's very rarely remarkable. Important? Yeah. Popular? I'd say not with half the country, maybe a little more than half. But not with half the country, and wrong in my opinion. I dissented, and I suspect wrong in Harry Reid. Okay, that's fine. But I'm saying he said the remarkable thing about it is, despite all that, there were not people killed in the streets. Yeah. There were not guns. There were not rocks thrown and people in hospitals. And when I talk to Stanford talking about this, I know the audiences at the colleges too. And I say that, and you say, "Too bad there weren't a few riots." I say, "Really? That's interesting." I say, "Turn on the television set. Turn it on and see what happens in countries that decide to decide their major differences that way, rather than under law." Now, that is what, more and more, I have to explain to people from farther and farther away. From Africa, from Asia, Latin America. And it isn't enough for them to come and look at a court proceeding once. That isn't the point. The point is to establish in the minds of people who are not with us, that are all over the villages all over the place, that it's in their interest to do those very tough things, sometimes follow a rule of law, which means sometimes follow things you don't like, could be wrong, that are very important, and that are unpopular. And until that notion comes across, we won't have it. But the good part is more and more people will have felt about that. It's unbelievable.
Thank you very much. I'd like, before we take a couple of questions, because given the audience that we have here, I'd like to focus in on the last couple of chapters of your book, Making Our Democracy Work. Talk about the president, national security, and accountability. And in the chapter, you pose a question, essentially a key question, which is that in practice, to what extent can or should the court hold the president accountable to the Constitution in the face of war or national emergency? And you talk about Lincoln's suspension of the writ of habeas corpus. You were talking about presidents who didn't follow the rules. The court said, don't move all these people with Japanese ancestry. Roosevelt says his man ignored that rule. When you think about today, what lessons would you draw from the answer to that question about the Constitution, time of war, time of national emergency, where we are today, particularly as you end the book a little bit about one hour?
I do. I've read some subsequently over the summer. I was reading Chief Justice Rehnquist wrote a pretty good book. I thought a very good book about the Constitution in wartime. And I ended up thinking, I ended up thinking that there are, I would say, three maybe basic views about separation of powers, the president's power. The problem comes about because the Constitution gives to Congress and the President, not to the court, the power to protect our national security, which is keen in wartime and can exist in other times where there's serious security threats from abroad. At the same time, the Constitution gives to the court the power, primary power is, to protect basic civil rights as is listed in the first 10 amendments and sometimes elsewhere in the Constitution, habeas corpus. So what happens when they clash? That's the interesting and difficult problem. One view is Cicero. He said, leges silent armes dicent, or something like that. I translated that as when the cannons roar, the laws fall silent. I thought it was a pretty good translation. Somebody pointed out, the Romans didn't have cannons. Yeah. But anyway, you get the point. Another view, maybe it's four, another view is, well, and then you find cases that say this, the president's foreign affairs power and related security powers are for the president. And we don't, although the Constitution may speak about it. They're not the kinds of constitutional issues that judges can adjudicate. You might call them politically questioned. Some other language, right? That's less common now than it was. For a while, that view was in the ascendancy. A third view is, yes, we can hear those cases, and we will. This is Curtis Wright, it's a great example. We'll hear it, but the president always wins. That's Korematsu, too. And the fourth view is, no, we have to at least, we've got to figure out something. And I think that's one time. if you go back, you'll see that Cicero's used never in the law in the United States. During the Civil War, there were a lot of civil liberties violations. Seward apparently said, he was talking to the British ambassador, and he said, you know, I have a bell on my desk. I ring a bell here, and I can have a person in Indiana thrown into jail. And I'll ring another bell, and I can have someone seize somebody in Tennessee. He says, can the Queen of England do as much? A lot of people. Well, but there was an exception. Well, but Lincoln wouldn't go too far. He did say, shall all the one laws but one, go unenforced, and the nation itself fall to pieces, lest that one be violated. He was thinking of habeas corpus. He was thinking of he's going to put people in jail without any proceeding, and he has to. But what he did just after saying that is he got Congress to approve it. And once Congress approved it, it was fit within the suspension of habeas corpus clause. So then there's a case ex parte militant right after the war, where in fact 9 justices of the United States Supreme Court said that a person who had been tried in Indiana for treason, because they did have some kind of elaborate plot. They were tried by a military commission, and 9 justices of the court said, no, you can't try this person by a military commission when the ordinary courts are open. 5 of them said you can't even do it if Congress approves of it. 4 of them said you can't do it because Congress hasn't approved it, we'll worry about it later. Or if they do. Obviously, so it's never been true the courts have been totally out of it. Now, what we got, if I jump up and what I think was happening in Korematsu, which I've discussed here, what I think was happening was this. It's an amazing case. 70,000, should I pause for all this case? It's very, very interesting. 70,000 Americans, wasn't so interesting for them. 70,000 American citizens of Japanese origin are taken from their homes in San Francisco in early 1942 and moved to camps. How did that happen? Well, General DeWitt, who was the 6th Army Presidio of San Francisco, said that he was worried about 500 or 700 incidents of sabotage. People were worried about invasion in January 42. I can remember the blackout curve was going down. I can remember that. And they were worried about that. And he said, there have been all these incidents of signaling to submarines and sabotage, and I've just got to move everybody. Roosevelt signed the order, and they moved everybody. Well, the general word among the Japanese was, don't rock the boat, just take whatever it is. But not everybody. Fred Korematsu, whom I once met, he was actually in Cambridge. Our next door neighbor was a woman whose maiden name had been Ann Besig, and Besig was a civil liberties, head of civil liberties in San Francisco at that time. Ernie Besig used to play poker with my father. Korematsu was at her house. So I went over there. He was a very feisty guy. And he was great. And he wasn't going to put up with this. And so he said, this is America. They can't do that to me. I was born here. I was a citizen. The ACLU wouldn't represent him initially. Besig had to do it on his own, which he did. And he thought he was going to win. He got to the Supreme Court by 44. And by 1944, there were a couple of lawyers in the Justice Department. Burling and I think it's like but they had gotten awfully suspicious about this whole thing. So they had called in the FCC and said, well, how many sabotage signaling was there? Can you look into that? And the FBI too. And they came back about 3 weeks later. And the FCC, a stack of stuff. So they said, well, what does it show you? There wasn't one. There wasn't one. There were incidents, yes, but nothing to do with the Japanese. Mostly they were buck privates who didn't know how to work the machine. And as for sabotage, they all took place. There were 4 or 5 incidents, but they were local, and they had taken place after the removal. So he said, how did you do that so quickly? He said, we didn't do it quickly. This was all around, this information, and DeWitt knew it at the time. And the FBI, by the way, didn't have those incidents. But the FBI, A.J. Edgar Hoover was totally against the removal. Completely. He said, the FBI can do this, you're going to have to remove 70,000. There are a few that would be fine. And the person most for them, one of the people, Earl Warren. He was Attorney General. He later said this is the worst thing he ever did. But it wasn't good. Or he gets to the court. Read the opinions. My goodness, who is right? Black, Frankfurter, Douglas. These are great civil libertarians, turned out to be. So I said, well, and the dissents, 3 really good dissents, actually. I think Roberts, Murphy, I think, wrote the best dissent because he said, well, but there's no basis for this. You know, and Jackson wrote a complicated, interesting dissent. Well, there we were. I said, why did they do this? So the best of it is my own reasoning, no reason. They're thinking, as Murphy says, you know, you should do this. He rather proves his point, to me. And I think what they're thinking is, all right, maybe, but if we say no to this, we're going to have to say no to all kinds of things, and we can't do it. Somebody has to run the war. Somebody has to. Either Roosevelt or us. And we can't. And so Roosevelt has to do it. And we have to approve it. Now that's not a popular result. And moreover, I think history shows they didn't have to do that. Well, we don't know yet. Guantanamo takes a different approach. By the way, the steel seizure case, famous case, takes a different approach. The steel seizure, and also in our Guantanamo cases, if I were to characterize them in a word, there were 4 people incarcerated in Guantanamo who brought cases that got to the Supreme Court. They were not popular people. One of them was bin Laden's driver, and he's not the most popular person in the United States. But in each case, they're suing the President of the United States or the equivalent. And in each case, they won. The President lost. And what's the theme? I take as a theme a sentence that Sandra O'Connor wrote in one of the opinions, which I joined. And she said, you can say this, the Constitution does not write the President, even in wartime, a blank check. No blank checks. Now, that's a great slogan. But the people who criticize our side of this case say, well, that's just a slogan. What are the details? And the majority say, well, don't write more details than you have to. We don't know what's going to happen. This isn't just some kind of theoretical legal thing. These are instances where the President and Congress are trying to protect the country. And we don't want to write them a blank check. And we'll say they went too far in some of these with suspending the writ of habeas corpus without a cause, or without, so they went too far in having the military tribunals every year, or they went too far, whatever the ways that were. But it was, don't say too much. That isn't, everybody hates that. Civil libertarians hate it because they haven't protected a lot of things, and the security people hate it because they say it leads to disaster. So that is the nature of a major security, civil liberties problem today, and it's really going to be history that says whether people took the right approach, which we hope they did, we did, and sort of fill in what can be done and so forth.
So we've used up most of our time. Would you be willing to take a question or two from the audience? So we have a mic. Yeah, come here in the front. We'll take 2 questions. Please.
Thank you, Justice Breyer. I'm so honored. I'm an education professor in Ohio, and I do my best to promote democratic lifestyle, classroom environment, and encourage social studies teachers that I work with to teach about controversy and teach critical thinking. And I've read your dissent in Garcetti. So the question is, in a post-Garcetti environment, what advice do you have to teachers who want to teach about controversy and do powerful social studies teaching?
I guess my self-interested advice is start by teaching the students, particularly in high school, what are the elementary facts of how government works? And particularly, what do courts do? What does the president do? It used to be called 12th grade civics. I think it exists in most places, but some it doesn't. And my reason for thinking that that's so important, by the way, if you want controversies and how people handle it, it's filled with controversy. There are films about the Cherokee case. There should be films, and there are, because they did a great documentary, actually, for Voice of America on the Little Rock 9. And then they wouldn't let them show it in the United States. Well, show it now. I mean, I'm not saying break the law, get it changed. Yeah, there are all the controversies you want in that and more, then you can add your own. But the main thing, why I think it's so terribly important, and what I frequently say to the foreign visitors, is, well, we have to say, no one knows that those values that we've grown up with, that understand courts, that understand the rule of law, that they'll continue. You don't want to like have a Chinese cultural revolution and cut off the inheritance to the next generation. Of course they have to know and understand that. They have to understand, for example, and I'd like to think everybody understood that, but this document does not tell people what to do. What it does is it sketches very broad boundaries for a system that other people decide what to do. In particular, the public decides it, the citizens decide it through the ballot box where they will elect people to go and vote. That's the theory of this. It's democracy. It's a certain kind of democracy. It's a democracy that's protective of basic human rights. It's a democracy that assures a degree of equality. It's a democracy that divides power horizontally and vertically, horizontally 3 branches, vertically state, federal, so that no one becomes too powerful in government. And it's a democracy that insists upon a rule of law. That's the outline. And then it fills in some details. And the details plus the outline are boundaries. That's what do I feel like? When I grew up, the Sergeant Preston of Yukon. He was the boundary patrol. It was very cold and miserable up there in Canada. But the point is, those boundaries can be tough. Is abortion in or out? Is prayer in schools in or out? Well, those are hard questions. But people forget that those are all boundary questions. And there is this vast area over which judges have no control and shouldn't. And the decisions about what cities, towns, states, and nations we want will be made in the ballot box. And one point I would love to get across every college, high school student in the country is, by the way, it's not going to happen if you don't take an interest in public life. By the way, I can't tell you what to do with your life. You know, I can't tell you, I'm just one person, I can't tell you. I hope you have a good career, I hope you work, I hope you have some kind of loving relationship, family, be wonderful, and I hope that you do participate in the civic life of your community. I would say, I can't tell you to do it, but I can tell you I believe, and I do have expertise here, that this document will not work if you don't. And that's certainly true. See, so you see what I would love you to do? All right.
I'm Jim Nathan, and I'm from Shelby County, Alabama. And there was a puzzling case, as you well know, from my perspective, that revised the supervisory courts in voting in places like Shelby County. And is that the end of it? Is that all?
Is that the end of what? There's one good thing about this country, or bad thing, is there's never an end of everything.
I mean, it's calling up-down, you know. And I know you were in dissent on this case, but it seems to me it is such a case that's at odds with what is.
Well, I can't comment about the particular case, but the voting in general is a matter that is also, in general, left to the voting. We do sometimes get issues that call for constitutional decisions. One person, one vote, constitutional issue. We had a case which asked us to look into gerrymandering and whether we could deal with that. A majority of the court thought the courts can't deal with gerrymandering. I thought we could, but only minimally. And I wish we'd come out the other way, because I think it might have helped. On the other hand, the majority thought it wouldn't have helped. So therefore, we're in a situation where not. That doesn't mean you can't help. That doesn't mean there's no law that stops a city or a town or a state from not gerrymandering their district. There's no law that stops them from having neutral commissions that draw lines. They do that now in California. There is no law that requires them to allow judges running for office to have enormous campaign contributions from different potentially interested parties. There is no law that stops people in the states or cities or whatever from trying to improve what we see as a polarized situation in dozens of ways. There are plenty of suggestions around. So those who are interested in civic life, whether the Shelby case is at an end or not, have plenty to keep them occupied. And what I like is a mean quotation, by the way, but I'll put back you for a second because it's a mean quotation. I found it in Derek Clark's book about education. He says that Pericles at the funeral oration in ancient Athens, he says, he's talking about Athens, you know, how great it is. And he says, it's Derek Clark says, he says, and what do we say in Athens of a man who does not participate in public life? We do not say he is a man who minds his own business. We say he is a man who has no business here.
That's a great place to end. That is, that's a